Matter of People versus Chelsea Sue Brink. This is file 26-7004FH.
John, am I going back to people?
Larry Brown on behalf of Ms. Brink.
Thank you, ma'am. Are you Chelsea Sue Brink?
Yes, sir.
Welcome, Ms. Brink. We're here for a status conference today. Have you been able to maintain good contact with your attorney since this case has began?
I guess, yeah.
Well, why don't you help me understand why that would be an acceptable answer to the court when you say you guess you've been able to maintain good contact about felony matters with a habitual fourth designation?
I'm sorry?
Why don't you help me understand why you guess that you can't stay in contact with your attorney when the charges are felony in nature with a habitual fourth designation?
Well, initially he was really bad at answering the phone.
So what about now?
I haven't tried him lately. I gave up.
So that gives me significant concern, Ms. Brink. It should give you significant concern. As I recall, you've had a attorney-client relationship with Mr. Brown stretching back many years. Perhaps I'm mistaken, but I think even the last time that you were perhaps in front of me back in around 2020, Mr. Brown was your attorney then. Is my recollection accurate?
I'm sorry, I'm confused. What does this have to do with what we're here to talk about? I've talked to him.
Ms. Brink, what it has to do with is, as a trial judge, one of my many duties is to make sure that in the context of criminal cases, the alleged criminal, you, the defendant, and the defense attorney have maintained clear and consistent contact. Because if I don't make sure that's happened, what happens later is that there are claims made in appellate context that there was some sort of a problem. And what I have to do then is repeat trial court proceedings. So rather than allow that to happen and repeat trial court proceedings and waste a bunch of time, resources,
I've
and
already
money,
asked for a new attorney
I
several
don't-
times in
yeah.
the beginning.
Ms. Brink, you've asked me the question. Now I'm clarifying it, and I'm not going to have you interrupt me. So the reason I start the proceeding with, have you been able to stay in good contact with your attorney, is to make sure that your rights are protected, make sure that the trial court process is protected, and make sure that I don't have to do this hearing again in the future. So again, now that I've explained the basis for what is a fairly simple question in the context of your charges, which you're facing felony charges as a habitual offender fourth offense notice, I'm going to go back to the original question. Have you or have you not had enough time to stay in contact with your attorney?
Yes.
That was relatively easy. Mr. Brown, do you agree with Ms. Brink after that discussion that you've been able to maintain good contact with her?
Yes, Your Honor. And just to clarify as well, we have gone over the offer in this matter. There's been two offers. Well, I will back up a little. After speaking with her, I did speak with the prosecutor further. There has been a revised offer in the matter, which I also went over with her, and that is how I believe we are going to proceed today, is with a plea. I would note for the record as well, she is currently on felony probation out of this court, and I just received that recommendation yesterday.
I'm on misdemeanor probation.
All right, I appreciate that
Yeah, that is
clarification. Certainly that's something that I need to be aware of. Mr. Brown, does that sound accurate, misdemeanor probation?
It does, Your Honor. I'm sorry, I was looking at the case number rather than what was pled to.
All right, so it was originally a felony charge, but it was pled to a misdemeanor. Is that accurate, Mr. Rollo?
That's correct, Judge.
All right. And Mr. Brown or Ms. Brink, is it true that you've been able to go over plea agreements with Mr. Brown?
Yes.
Is it true that you understand those plea agreements?
Yes. The only thing I'm questioning is, and Larry told me that my probation violation charge was going to be dropped. And then when I reported to probation on Tuesday, she said that I had in district court for a probation violation hearing. So I'm confused about that, and I'd like to speak to Larry about that before.
Is there any part of a plea agreement that involves dismissal of a probation violation in a different court?
Yes, that was part of the original plea agreement.
Well, Ms. Brink, you should listen carefully, because there's some things the court has control of and there's some things that the court doesn't have control of. It's harder for you to see and hear because you're not here in the courtroom, but Mr. Rollo, the prosecutor, is here in the courtroom. And what he just indicated is not a part of the plea agreement to have a dismissal of a probation violation hearing in the district court. That's not something that the court controls. That's something that the prosecutor's office or Judge Hesselink in the district court does control, not me. So, Mr. Brown, is it consistent with your understanding that there is no agreement to dismiss a probation violation that's existing in the district court?
That would be my understanding. I don't know if the court would allow the recommendation for that violation is time served and discharge.
Well, I don't
Thank you.
have any say over that, and that's not something that's part of this case. It's not my matter. So
And
it's
I-
either part of
It's
the
part of this
agreement.
case.
It's not part of this case, Ms. Brink, so let me clarify why. I'm not the district court judge. I don't control Judge Hesselink's discretion, and I don't purport to have his discretion exercised in this court. This case revolves allegations of resist or obstruct a police officer, 2 counts, 1 count of mail and mail depository protection act theft, and 1 count of trespass. That's the only things involved in this case, unless and until both attorneys tell me and I accept a recommendation that involves anything else. And so far, I've not heard that, and so I'm not willing to accept that. Mr. Brown, can you tell me what the terms of the plea agreement are in this case?
Yes, Your Honor. The terms of the plea agreement, as I reviewed them with Ms. Brink, are plea to count 1 as a habitual second, count 4, and the remaining counts as well as enhancements would be dismissed.
Is that a great statement of plea, Mr. Rollo?
Actually, Judge, I thought it was counts 1. Let me verify this. Because that's what I have written down, because it involved the mail matters, and we want to make sure restitution is covered. Judge, my final notes indicate and Ms. Brooker had communications with the defense counsel on, looks like May 7th. And it was count 1 as a have to and count 3 for dismissal of counts 2 and 4 as well as the habitual court.
Mr. Brown, did you misunderstand the plea agreement, or do you have different notes?
Your Honor, that is correct. That was the original. However, back toward the end of June, and I don't know if this was Ms. Brooker's case, but I did speak with Mr. Fortier, and we had discussions, and that is when the offer was revised to count 4 rather than count 3 would be the plea.
And again, Mr. Fortier in our office did indicate that, and my office is bound by it, and I'll accept that, Judge.
Well, how would that be how would that in fact happen if you don't have notes to suggest it, Mr. Rollo?
I will be speaking to Mr. Fortier about that very subject.
Well, to the people, it sounded like your concern was restitution. Restitution can be preserved in any event, did it not?
Well, again, there's some, as the court's well aware, there's some appellate decisions indicating that unless restitution is made specifically part of the plea agreement.
That's what I just said. That's what I just said. You could make it part of the plea agreement.
And again, that's what I would suggest. We have no objection with plea 1 and 4, as long as restitution is preserved as part of the plea agreement.
Mr. Brown, did you wish to be heard on that potential addition?
I have, knowing the facts of this case, I don't have any issue with preserving restitution in any count.
Ms. Brink, have you heard everything that's been said?
Yes, I don't quite understand what you mean by preserving restitution. Does that just mean I have court fines to pay?
Restitution is different than fines. There are fines and costs that are generally associated with any conviction. Restitution refers to if there was a loss suffered by a victim. So, for example, one of the charges suggests trespass. One of them suggests that there was destruction or hiding or concealing of mail. And to the extent the court ever determined that a victim was harmed and had identifiable and quantifiable restitution, monies that were lost, I would order it. And I would order it if I made that determination, regardless of whether or not there was any conviction for the charged offenses under the plea agreement. Does that clarify your question?
Yes.
Did you want to go forward under those circumstances with the plea?
Yes.
Raise your right hand. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes.
Ms. Brink, under this plea agreement, you're going to be pleading guilty first to count 1, which is police officer, assault, resist, or obstruct. Typically, that's a felony offense with a maximum punishment of 2 years in the state prison system and or a fine of up to $2,000. However, you're going to be pleading guilty as a habitual offender, second offense notice. Are you aware of that?
Yes.
Count 1 as a habitual offender, second offense notice is a felony offense with a maximum punishment of 3 years in the state prison system and or a fine of up to $3,000. Are you aware of that?
Yes.
Would also be pleading guilty to count 4, which is entitled trespass. Trespass is a misdemeanor offense with a maximum punishment of 30 days in jail and a maximum fine of up to $250. Are you aware of that?
Yes.
Restitution in this case would be preserved for any offense if the court makes a determination that restitution is owed and makes a determination as to the amount that is owed. Do you understand that?
Yes.
If there wasn't an agreement as to restitution between the prosecutor and the defense attorney, you'd be entitled to a hearing where I would consider and order whatever I thought was appropriate for restitution. You understand that?
Mm-hmm.
Is that a yes?
Yes.
The benefit of the plea agreement is that the prosecutor would then dismiss count 2, the other offense charged of assault, resist, or obstruct a police officer. The prosecutor would also dismiss count 3, and the prosecutor would dismiss the habitual offender, fourth offense notice. Do you understand those benefits?
Yes.
There are no other terms to the plea agreement. Do you understand that?
Yes.
Understanding all of those terms, the maximum penalty associated with count 1 is a habitual second, the maximum penalty associated with count 4, and the benefits of the plea agreement then, how do you plead to resist and obstruct a police officer as a habitual second?
No contest.
There's not been any discussion yet of a no contest plea. Ms. Brink, is there some reason I should consider a no contest plea, Mr. Brown?
Your Honor, that is just not what I had gone over with Ms. Brink. I didn't
Ms. Brink,
anticipate
there has
that.
been no discussion.
Guilty or
The discussion has only been about a plea and not about a no contest plea. A no contest plea requires the court to make a determination that it's appropriate. I'm not making that determination based on the record so far. Did you wish to issue a guilty plea or a not guilty plea based upon the circumstances?
well, I have a right to plead no contest. That's one of the rights under
You
the
do
law.
not. You do not have a right to plead no contest. You have an option to seek a no contest plea. And if you seek a no contest plea, the court has the right to either accept it or reject it. I don't choose to accept it because there's not been a factual basis that's been laid out for me to accept it.
Well,
So
the
your
thing is,
options-
I was injured in the arrest.
Ms.
So I'd
Brink,
like to
the
plead
thing
no
is, you can plead guilty under the circumstances as described if you want to, or you can plead not guilty. And if you plead not guilty, the matter will be docketed for trial and we'll get it on very quickly. But this is not a situation that is difficult, number one. Number two, I'm aware of the background circumstances with you, meaning this is not the first time you've been in front of me. And the reason I'm being so direct is because there has been difficulty in many cases that I've had with you previously in your apparent or planned lack of understanding. And I don't accept that because records in the courtroom should be clear. The fact that this record is not clear, in my estimation, is because you're trying individually to make
Not
it not clear.
guilty.
And I don't accept that. If you choose to enter a not guilty plea, Ms. Brink, you're entitled to do that. And if you do so, I'm going to set the matter for trial, and I'm not going to consider further plea agreements. This matter needs to be resolved for your benefit or for the people's benefit or for both. Do you understand what I'm saying?
Mm-hmm.
Is that a
Yes.
yes?
Yes, sir.
Mr. Rollo, to the extent this matter is tried to a jury trial, how many days do you need to try it?
Judge, in light of the number of witnesses, I think conservatively, we could probably get it done in 1 day because there's only 4 witnesses.
Do you think 1 day is enough for a trial in this case, Mr. Brown?
I do.
Is there any reason why the people need a specific time to prepare as long as they give you statutory notice? That's plenty.
Judges, no, it's going to be more the court's docket than it would be conservative people. Thank you.
Mr. Brown, any specific time period you need to prepare for trial?
No, Your Honor. Is this, because quite frankly, this was a little bit of a surprise to me. I was not expecting this outcome. Is this going to be considered a final conference or will we have that opportunity?
There may be the ability of the attorneys to convince me that I should set another hearing, but I'm not convinced right now. this matter needs to proceed. Again, for the reasons I've already dictated, I feel that it's a situation where Ms. Brink is being intentionally difficult. But if I've misunderstood the circumstances, the attorneys can rectify that issue and convince me. At this point, I'm simply going to set the matter for trial unless I hear differently from the attorneys. Does that answer your question?
It does, Your Honor. Thank you.
So in terms of the background, Mr. Rollo, do you expect there's going to be a need for any motions and or notices under court ruler statute?
I don't believe so. Thank you, Judge.
Mr. Brown, do you expect any motions?
Your Honor, I cannot honestly answer that. I know that Ms. Brink has had some different competency issues in the past. She was sent for a competency evaluation in this trial, I believe. She was restored. But again, competency is something that I have to take on a case-by-case basis. So if the issue comes up, I may potentially file a motion.
Well, if it would come up, I would expect you to file it immediately, but it has not come up yet, at least in the context of from right now going forward, right?
Correct.
Everything now. All right, so the court will bear that in mind. I'm going to set this matter for, again, a one-day jury trial at my next available date. I will order that motions and or notices under court ruler statute must be filed within the next 30 days, or they'll be considered time barred. That will give each of the attorneys time to re-review the file now that you know that the trial is upcoming. Trial dates are going to be set and they're going to be firm in this particular case, meaning it's not going to be stacked. Ms. Brink, I require that you're present no later than 8:30 on the morning of trial. That's the report time for the attorneys as well. And of course, I require full text jury instructions filed by each attorney at least 14 days before trial. Anything else, Mr. Rowland?
On this case, thank you, Judge.
Anything else, Mr. Brown?
No, Your Honor. Thank you.
See you at your trial date, Ms. Brink.
Bye.